Hello and welcome to today's webinar. Thank you all for coming. My name is Samantha Winters and I'll be co-hosting today's topic. Before we get started, please note that microphones are muted, but we welcome you to type your questions into the Q&A box at any point. We consider this webinar to be more of town hall style, so please just raise questions at any time. I'm obviously losing my voice today, so the more you all raise questions and interject, the better it is for me. So, and I'll make Les, my co-host here, talk as much as possible, so you don't have to listen to me. But just a few things our lawyers make us say, primarily that this webinar is for informational purposes only, and it's not a substitute for legal advice. So let's get into today's topic, which is more about second opinions when your patient is out of state or even out of the country in some cases. And today we're going to talk about what physicians and attorneys need to know about episodic exemptions, a new area of telehealth related regulation that we've been tracking here at Purview. And actually, Les, you recently presented at the American Telemedicine Association. We have Les Trackman here to talk about the nuances of state law and walk us through it. So thanks for joining, Les.
Thank you, Samantha. I thought for a little while that I was going to be doing completely solo today because I know your voice was giving out. But as you know, I never mind speaking too much. So that's an added benefit of you not having a good voice today.
Well, on that note, since I'm losing my voice, do you mind giving your own background and maybe even a background on what prompted your research in this area in the first place?
Sure. My name again is Les Trackman. I am the CEO of Purview, actually better known as Managing Director of Purview. And we're a company that provides a platform for second opinions, a software platform for second opinions. I am licensed as an attorney. I don't practice law, but I'm licensed as an attorney. And the reason I dove into this particular topic is when we first came out with the software and we were presenting it to institutions like many of you represent here today, one of the first things we heard was an objection that institutions were really worried about licensure and how could they cross state lines by giving an opinion in a state in which their providers were not necessarily licensed. And it just seemed inadequate for me. I mean, it's a good question, but it seemed inadequate for me that we have these really deep level specialists, that you have these really deep level specialists, highly trained, sometimes uniquely trained in their business, in their particular subspecialties. And for some reason, the law says that they can't give an opinion to somebody who needs it in a location in which that patient currently is located. And so I just thought that was inequitable and did a lot of research and was very pleased to find that in many cases, and we'll talk about that today, but in many cases, the provider does not need to be licensed as long as they follow through some of the ritualistic things that the states require. Not every state, and of course, every state is a little bit different. So we'll go through those, but we've got some really good tips and techniques for how to go about this. And I'm really pleased to say that we track 54 different jurisdictions, so all the states and some territories of the U.S., and as Samantha said, some other countries as well. But in the 54 territories that we track, something around 50 are okay for you to do this in as long as you follow the rule. There are a couple states that we don't recommend you do it in because either the language is ambiguous or the language is not accepting of an outside physician, for whatever reason, outside physician who's not licensed there to give an opinion. So sorry, that was a long-winded introduction, but it was valid. It's a really important thing to us at Purview, and I think to those of our clients that are trying to provide this great service.
Yeah, that was actually a perfect introduction because you gave my voice a rest. So before we jump into the state-by-state breakdown, I know it's always helpful for me to revisit these core principles or foundational principles, as we call them. Do you mind kind of walking us through these again? Some
Sure.
audience has heard them before, but it's always helpful.
Yeah, I think it's a good grounding to start out with. So most of us already know that the states or the territories control medical licensure here in the United States. It is constitutionally reserved, and that's an artifact of the original forming of the United States, where there was a negotiation between states and territories that didn't want to give up their rights to this newly formed federal government. So the states have retained control over medical licensure. That's tried and true. That is well known. Maybe someday it'll change, but at this point, it would take a constitutional amendment for that to change. So being that the states control, okay, so what state controls? And that's the next statement, which is it is the location of the patient that determines which state controls. Now that is very carefully worded to not say it is the home of the patient or it is the domicile of the patient. It is actually the location of the patient. And we have, funny statements that we make, but it's really true that in some cases a patient can get in their car and drive to a parking lot in the state in which a physician might be located. And because they physically are in that state, even though they're in a car in the parking lot and they've just driven there, that's okay because that state controls and that doctor might be licensed in that state. Weird as that might be, that is what the law says today. For second opinions, and these are typically remote second opinions, these are what we call episodic, meaning that it's not telemedicine per se. It's not a continuum of care that's being given. This is an event that occurs, and that event is what we refer to as episodic. And you'll see that and you'll hear that from us as we talk about the laws of the various states. And it is also clear and true. Sometimes it's even spelled out in the state's laws, but centers of excellence, academic medical centers, specialty care, those are the kind of things that are treated very differently. So if you're a GP, a general practitioner, you're likely not going to be able to fall under one of these exceptions or exemptions for virtual second opinions. So this is about specialists, and it is about what I would call a slightly rarer treatment or recommendations than you'd get from a general practitioner. But those are the foundation principles that we're going to use as we go through this, and those are the ones that are going to control the laws in each of the jurisdictions that we get to.
Yeah, that's great. Okay, so one other thing though, the other strategies that we hear about all the time, educational, or I have a physician license in every state. How do those come into play here? Do you mind just telling us a little bit about that?
Yeah, that's a good question. And actually, there was an article that was written that some of our clients pointed out to us that was a little scary. And it actually was the lawyer who chaired Nate, who chaired the panel that I spoke at ATA, who wrote that article. So it starts from this point of view. There is a storied institution, I won't use their name today, that was really the grandfather of remote second opinions. And when they started out, they relied upon the fact that they claimed a second opinion was for educational purposes only. It was not the practice of medicine. And that's how they claimed they were getting around the state control laws. So they weren't practicing medicine in any of these states. They were simply giving educational information to these patients. I would say a couple things, and I think Nate agreed with me in this, that one, if you are talking with a patient, whether that's synchronous or not, and we'll talk about asynchronous a little bit later, when you give a patient advice as a doctor, whether that advice is you're going to operate on them or that advice is you think they should go get operated on, that's practicing medicine as far as I'm concerned. And certainly if you're trying to keep your physicians out of trouble, I think you want to consider that to be practicing medicine. You want to make sure that you are doing that right. So the exception, if you will, for education is really not a good one to rely on. Now, there are certain ways that you can rely on that, like if you're a physician and you're going to give a speech in another state about a great treatment program that you've come up with, that is, in fact, deemed to be education. And that is in almost every state, I would say in every state, that's protected kind of behavior. So that was the first. The second that we hear a lot, and we hear this mostly from concierge kind of practices, and I think it's a remnant of telemedicine, or maybe it's a part of telemedicine altogether. There are some organizations, and there are in fact some hospitals that have either created a relationship with or have employed somebody who is a licensed physician in each of those jurisdictions in which they want to give second opinions. And they ostensibly say, okay, so now I've got a licensed physician in that state, so therefore I'm exempted, or I'm no longer worried about having a license in that state. And that's good to some degree, but it's not good in every case. And I like to make sure people are aware of this because most are not. And that's that if, in fact, the laws of the state say that the physician who has the license in the state has to have an existing relationship with the patient in order to give you that exemption, having a person that's a nameless, faceless, not related to that patient kind of physician who's licensed in that state does not get you past there. So you got to be careful about that. It certainly is a good start to have a licensed physician that you have a relationship with in each state, but that's something that's really important. The other thing that I hear, and this is related to that same topic, is that if I have a concierge or if I have a consulting firm that I'm working with and they're running my second opinion program, that the patients are patients of that entity. And I always pause when I hear that. I don't like to tell people that they're wrong, at least not directly, but they're wrong. And they're wrong for this reason. If something comes up with that patient and something goes wrong, you can be darn sure that that patient's going to look to the provider, not to the company that offered up that provider as the privity, as the contract relationship with them. And so I don't think that you can ever say that the patient is a patient of a third party when it's your doctors giving a second opinion. I'd be very careful of that as well and realize that it's your doctors giving that opinion and you need to protect your doctors. That company doesn't necessarily have that same relationship with your doctor, and it's not necessarily their job to protect that doctor. So again, I'd be careful of those two. The last piece, which is really one that we're going to talk about today, is the states have laws, and we need to follow those laws. And if we follow those laws and look for the appropriate exemptions or the appropriate exceptions, we can do this, as I said from the start. And this is not that difficult to do, but it does require that you follow those I would say laws or regulations of the state, and probably that you document them as well.
Yeah. We had a question pop up. If you don't mind taking a look and reading it. Actually, my voice is back a little bit. I'll try. Is the exemption criteria the same for advanced practice providers such as NPs, PAs, and so forth as it is for physicians? And actually, I was wondering the same thing. So that's a great question.
It's a great question. It's actually not come up, I don't think, in any of the webinars that we've done. But the answer is they're different. Mm-hmm. They're different. And the states sometimes will glom them all together and call them clinicians, and sometimes they won't. And there are different rules and regulations in every state that control NPs, PAs, and providers. And so you need to think about those separately. With that said, a lot of the regulations that we're talking about are similar from an exemption point of view, but I would check carefully in that state before I would, make that global statement that they're all the same. So they are going to be different in general. The same kind of approach is probably right, but I would check the state law to make sure that there's no differentiation specifically in that state regulation.
Good to know. Okay, that's a perfect primer for stepping into the states. Oh, we forgot to talk about this slide, but I think we kind of generally covered it, right? Anything you want to?
Yeah, I think we've covered it. This is not the same as telemedicine, not the same as making sure that you've got the right licensure for telemedicine. In almost every state, the license for telemedicine could be a separate telemedicine license, which are sometimes lightweight licenses, easier to get, et cetera. But they do require a license in almost every state for telemedicine. And that is the physician who's practicing has to have it. And the same thing, obviously, for feet on the street practice of medicine, you do have to have a license. So that's not what we're talking about here. We're talking about this episodic thing, which does set it apart.
Great. Okay, so if you don't mind giving us an orientation to the map, and for those that have listened in the past, we didn't completely change this map, but we updated it to become more granular, I would say. So maybe you could give an overview of that as well.
Yeah, I think we're getting better at this, which is which is helpful, I think, for all of you in terms of making sure you've got this compliance down. So what we found in general in the survey that we've done, the detailed survey that we've done of the laws and regulations in each of the states and territories that we review, is that there really are, we'll call it five, because that's what you've got here in terms of the colors on your map, five different ways of going about compliance or not in the various states. And so we'll go through this distinction, but they range all the way from it's okay as long as you're we're talking about physicians here, as long as you are a licensed physician in your own state and you're in good standing. In some states, you're going to be permitted to practice medicine in this episodic way. In some, you got to do it in concert with a local physician. In some, as I mentioned before, it can only be done at the request of the local physician. Some of them have language that's either ambiguous or non-existent, and some of them simply say, no, can't do it. And we'll go through each of those just so you know what they look like when you start looking at them. And we track all this stuff, so we have all of the citations for each of the states in terms of what the regulations are.
Great. So let's start with the example of prohibited or free only states. And I know we have Utah here.
Yeah. So there's a couple of states that fit this criteria. Utah is one of them. And Utah is an interesting one because it actually says you can do this. So you can episodically provide a remote or virtual second opinion to a patient who happens to be physically located in Utah. The only problem in Utah is you can't do it for money. So if you're doing it out of the goodness of your heart, or you're doing it altruistically, or if you're doing it for charity, you can do it. But if it's commercial, you can't. And their law is very clear. And so we typically say, at least in the commercial practice of second opinions, that you avoid patients who happen to physically be in Utah.
So that means even if they're not paying you for the second opinion, but if they matriculate as a patient, would that also fall under this?
It does. So typically the way this is reviewed from a value point of view or other consideration is if you give them advice so that they will come to your state to get a procedure done, that's the same as a commercial practice. So that's prohibited as well. So this really is, unless you're doing it for free, don't do it.
Got it. Okay. So we have Massachusetts, which is one of the ambiguous states. Maybe you can go into that one.
Yeah, Massachusetts is just plain old problematic. And I'm guessing, I make this up, but I'm guessing that Massachusetts has the regulations this way because they have lots of doctors in Massachusetts that they're probably trying to protect. And they have some good specialists there. So any of you happen to be from Massachusetts, I'm not disparaging the quality of the medical care there. But what we found in Massachusetts is the language is very straightforward. However, it's missing. It simply says that if you're going to practice in Massachusetts, you got to be licensed. That's it. There's nothing else. And you sort of say, wait a minute, can't you tell me what's going to happen here if I'm doing this episodically? And they say, no, we don't say that. So we look at that and say, it's probably not going to be a state where somebody's going to come after you. But at the same time, there is no enabling language. So as a lawyer, putting my lawyer hat on, I would say, I can't tell you should do this in Massachusetts because I can't rely on anything other than my own sense of propriety and say, hey, you should be able to do that. But I would say in Massachusetts, it's one of those states that you have to be really careful of. And many of our clients don't give remote or virtual second opinions to patients that happen to live in Massachusetts just because there is no real language for them.
Mm-hmm. Makes sense. Okay, what about California?
Yeah, so California, and it's funny because a lot of programs avoid California, and I'm not sure why, but in California, the language simply says that if you're doing this episodically, if you're providing a second opinion episodically, which is what most second opinions are, the state of California says that if you do it in concert with a local physician, then you're okay. And what that really means, what the in concert language means, is that it's like parallel play. You should make sure that there is a physician in California that has a relationship with the patient so that when you give this patient your opinion, if it means they need to, or you're recommending that they should go get a procedure done, that there's somebody they can talk to that actually understands what it is that you've said or you've given to them in terms of recommendations. So this is a very standard kind of language, and you're going to see this popping up more and more and more in a lot of the states. And that's that they want to make sure that there is a physician in their state that, one, understands what the state requires, but that can be that liaison, if you will, with the patient. And I view that as good practice. Now, it does put a little burden on you, or maybe a lot of burden on you as a practitioner outside of California, that you probably should document this. And that means you should probably get the name and the NPI of the physician so that we have it in the record somewhere. You probably also want to get that physician to acknowledge. So maybe sign something that says, "Yep, you have begun to engage me, and I am working with this patient, and I will help you interpret that for the patient." So that's it. This is very common language. This is going to become more and more common, I think, as you see states start to embrace the idea that the world of tele now applies to all of the people in their state.
Right. That's really interesting. I know as we updated this map this time around, we had many more that changed over to the in concert with. Is that right?
Yeah, I think states are learning and they're clarifying, and they realize, so states do not want to restrict great care from the patients within their state. But they do want to make sure that they can regulate what's good and what's bad. They don't want charlatans coming in and saying, do this, do that, and snake oil kind of answers to to patients in their state. But at the same time, they know that there is some uniqueness to some of the care that's around in other places, and they want to make sure their patients are taken care of.
Yeah. Another comment that I was just thinking as we were talking about California, I think it's medical malpractice that keeps some folks away from California. It might have a higher medical malpractice.
It could be medical malpractice is another layer that we have to talk through at some point. It's not going to be something we talk through in this particular webinar now, but obviously you want to make sure that your coverage covers these physicians, your physicians, when they give an opinion in another state. So they need to know something about these exemptions as well. And that's certainly something that they can be educated on.
Right. Okay, so let's talk about Alabama, which is in concert with, but it has a limit to the frequency.
Yeah. So this is also, there aren't that many states. I didn't write down the number. Maybe, oh, you did probably on the card. And I'll show you this card a little bit later. We created this for ATA, but we have some of these available. There are a set of states that have specific frequency limitations. It's 1, 2, 3, 4, 5, 6 or 7 states now have that. And the idea of this one is you can do the same as you could do in California. So you can provide a second opinion remotely if you're a physician in good standing in your own state, as long as you do it in concert. In this case, in concert with a physician, and as long as you don't do it more than 10 times in a calendar year. And that's really, maybe it's defining episodic more than it's defining anything else in this. So Alabama is saying episodic is 10 or fewer times for a particular provider in this state. So remember that as well, because we've had some institutions that have come to us and said, well, 10 is very limiting. And I would say, yeah, 10 is very limiting, but realize that's one doctor doing second opinions 10 times in a year in a state. So far, we haven't seen any institutions where we've even come close to that number. Right. So it is a limitation. Now, not every state uses 10. A few states use words that deal with limitations, and a few states use numbers that are different than 10. And we have all those regulations that we've looked at. But Alabama is a good example of a limitation in numbers.
Right. And someone actually brought that up in the Q&A box. It was more of a comment than a question, I think, in their review, that episodic is not always clearly defined. Sometimes it's occasional, sometimes it's infrequent. So to your point on frequency, it could just be described versus prescribed, I guess you could say.
It could be. And then you've got to use, a reasonable judgment as to what that really means. And I think there's I think it's easier than it looks in terms of that. I think if you do it, if an individual provider does one or two or three remote virtual second opinions in a state, assuming the state doesn't have a limitation of less than three, I think you're just fine. I think
Yeah.
when you start going higher than that, reasonably, you're starting to say, okay, 4, 5, 6, 10, 12, 20, that's not infrequent anymore. And I think you have to think about that. So probably you need to put your own logical hat on this and form an opinion. But I kind of go with if a state uses words like infrequent, you ought to make sure it is infrequent. And again, that's by provider, not necessarily by institution.
Yeah, I think that's a good point because that is mixed up a lot, that it's based on the physician, not on the organization. So Mississippi is when requested by local physician.
Yeah, so this is a little different. This is a little bit of a curve that they throw at you. So this is not just in concert with a local physician, but this is when requested by a local physician. So that means you have to be brought into the state, at least ostensibly brought into the state for this particular patient by the physician. And so a lot of people come to me and say, okay, well, what does that really mean? And how to really make that happen? Is a doctor really going to call me up and say, please come in and help my patient? And the chances are that they're not. That's not the way it's going to happen. The way it's going to happen is the patient's going to seek you out or seek out your institution and engage you to give them a virtual second opinion. And what you're going to need to do to satisfy this state is you're going to have to say to the patient, is there a physician that you're working with that you have a relationship with already? And they'll say, yes, certainly they have some physician. Even if it's a GP, that's okay in their state. And you have to say, okay, would it be okay if I ask them to formally engage me by asking me to help you? And typically the answer is going to be yes to that, but that's what you need. Our suggestion is that you document that. And we actually have a little form that we use within our software that enables just a form email really, that enables you to put in the record. So paper your record with this, that the local physician of that patient signs that says, yes, I've made this request. And that's what you need to have. And that's typically the way it's going to happen. Samantha, you're on mute.
Thanks.
Or your voice is given out completely. I'm not sure which.
I was muting myself in between so I could have sips of my tea. So Montana is the last one we have on our list, which is permitted without local physician. And would you say this is the most, permissive?
Permissive, yeah. And I think there are only 3 states that I think that's what we have on here now. Yeah, 3 states that have this regulation. And Samantha, you're 100% correct. Things have changed a little bit in the last even 6 months. And this is a very dynamic field. So you've got 54 states and territories that are changing their laws on a regular basis. And you can imagine every year there's a few that change. And in this world, that's what's happening. But Montana is one of the most permissive. They, along with Arkansas and Colorado, have the distinction of allowing physicians who are in good standing in their state to actually provide an episodic, a remote second opinion with patients who happen to be located within their states. This is valuable. These are the 3 easiest states. When somebody says to me, no, I can't do it because the laws are very complicated, I would say, yeah, in these 3 states, it's not complicated at all. Obviously, there are other ones where you have to follow prescription a little bit more carefully. I still think in these states, you should form a relationship with a local physician who has a relationship with this patient, knows something about the patient. I think you should do it. I think it's good practice. If nothing else, it gives the patient a fallback to somebody who is familiar with the practice of medicine and, again, can do some interpretation for you. So even without this permissiveness, I think it's still good practice and probably should do it and paper your record with it. Have a local physician engaged when you do a second opinion.
Right. And I'm sure that's why some of the states have been converting over to the in concert with language, because that continuity of care is important. And we know from working with some of the hospitals that we work with that they're good at that, establishing that continuity of care and they'd probably do it regardless of whether it was required.
It is, and there are great statistics for what we call conversions. So a conversion. The way we describe it is a physician from out of state renders a second opinion to a patient in another state, and that patient says, I like that opinion. I'm going to follow up on that. That follow-up could mean that they travel to your state, to your facility, and get a procedure or treatment done there. Could be that. But the chances are that it's not going to be that. The statistics are not 50% of those patients will come to you, even if you're great at what you do. It's some large percentage, which is meaningful, like 20. But even if it's 20, 80% of those patients are likely going to either continue with the care that they've been getting or request the care related to your opinion, but locally for them. So having somebody that can help them with that locally, at least guide them, direct them, or again, perhaps interpret for them, is really important. You don't want to leave that patient with you should have this monumental procedure done, and the patient goes, what does that mean? And you don't want to leave them like that. It's not a great practice in medicine to do that. So we do suggest you make sure they engage a local physician.
Yeah, that makes sense. Okay, so maybe you can give us a quick summary of everything you went over, as well as maybe where you see things going. We talked about that a little bit. And for those of you that asked, a couple questions popped up on whether you'd be getting a copy of the recording or a copy of this card. We will follow up for everyone that's here should have registered. So we'll follow up with an email where you can put in your physical address if you'd like, and we can mail one of these to you if you'd like to kind of have it on your desk, so to speak. But the QR code here, as well as the link in the email, will take you to the interactive map if you haven't seen it before. But Les, if you don't mind saving my voice and giving a summary, I'd appreciate it.
So I'll give a summary, and with regard to questions, we'll perhaps be able to get to some of these questions at least. There's a lot of questions that have been asked, but we'll try to get to some of them before we're done with this session. And if not, we can probably follow up with each of you. So I would say in summary, well, first of all, we have this card, the card that's pictured on your screen. We have this card. We created these for the ATA, but they're really valuable cards because they got this little QR code on it, which then gets you to the place that Samantha's talking about, which is more information about the states. So there are different regulations in each state. The states generally fall into these 5 or perhaps 6 categories. If you count the specific number limits as one of those categories. You should know what those are if you're going to have your physicians practice in those states, but do not get scared by that. Again, there's only a few. There's actually 3 states or 3 states and territories that we suggest you avoid for today. Utah, Vermont, and I believe it's the Virgin Islands are the 3. And that's just because it is down there on the card, the Virgin Islands. So that's just because the language is prohibitive. It basically says don't do it, or in the case of Utah, don't do it unless you're not getting paid. So of the 54, there are 51 that you shouldn't get scared from, and you should be able to do it. You just need to put processes in place to ensure that you've got this under control, and that if God forbid something happens and somebody comes after you, a state or perhaps a patient, because they didn't like what you said, you want to have everything documented because you don't want to be on the wrong side of the law or those regulations. And there's one that was mentioned in this article that Nate wrote that's actually a 2010 case. So as I like to say, pre-COVID, where there was a lawsuit that occurred and there was a finding that a remote physician practiced incorrectly. In this case, it was at a lab. So it was like a LabCorp kind of environment, and a physician at that entity, I don't think it was LabCorp, but a physician at that entity issued an opinion. Something bad happened to the patient. They got sued and they were found liable for practicing without a license in that state. They didn't follow anything close to any of these regulations. So it shouldn't be a chilling kind of decision, but it's a very thin decision, and it's been a while since that occurred. And it's only one that we found that is like that. Now, with that said, there are a couple of lawsuits that are telemedicine related that have been filed in the last couple of years. And those have been filed, those of you who follow this area, those have been filed to try to expand the laws as opposed to constrict the laws. So there was one filed in California and there was one filed in New Jersey. They both were about telemedicine. So continuum of care, which is when a patient actually physically went to see a physician in a state in which they were not living. So in one case, a patient went from Boston, I think it was Boston, and somewhere in Massachusetts to New Jersey, and then went home. And this was a prophylactic suit filed by an organization saying now the physician in New Jersey can, maybe it's the other way around. Sorry, it is the other way around because they went to Boston Children's to get treated actually. So it was a New Jersey resident went to Boston Children's, and when they went home, the lawsuit was filed because it said the patient can no longer follow up with the doctor in Massachusetts because the law in New Jersey says that you can't practice medicine in New Jersey without a license. And so that suit, which was brought now a couple of years ago, I think that's the one that's still pending. I believe it is the one that's still pending. The goal for bringing this lawsuit was to change the law. Obviously, it's going to try to impact and help that patient, but it's to change the law. And the other one is in California. That one actually has been dismissed. So the California courts have dismissed that case. The plaintiffs allowed it to be dismissed, even though the judge gave them leave to change their complaint. They allowed it to be dismissed because they want to appeal it and they want to change the law there as well. So these two are monumental. They're not necessarily on point for remote second opinions, but they will have an impact if the laws get expanded, which is what they're trying to do. It will only help in terms of the availability of these opinions as they go forward.
Right. And for the one that was dismissed, for those of us that don't have law degrees, maybe you can just quickly tell us why it's important that it's being appealed and going to the next level, because I always
Yes. So in order for a case to be appealed, there has to be a judgment, and a judgment of dismissal is a final judgment on that case, on the merits of that case. And so now the plaintiffs can appeal it. They couldn't appeal it unless and until there was a judgment. The one in New Jersey is still pending, so they're still wrangling about what's going to happen there, but there is no judgment, so they can't appeal that. And when they appeal it, they appeal it to a court of higher authority, as we like to say in the law, and that could potentially create at least common law, so at least precedent for what could happen in the future. Now, we all know that precedent sometimes doesn't get followed, as we're seeing a lot in the geopolitical world that we're in today. But that's what the goal of this lawsuit was, is to get an appealed decision so that we can have a court of higher authority actually say this is what the law is interpreted to be.
Yeah. Okay. So we were going to switch gears and talk a little bit about international law. Most of our programs that run domestic second opinions also run international second opinions under the umbrella of global health at times. But before we jump into that, there was one question that is more oriented towards the domestic licensure. So maybe we can answer that one. And then the other ones we'll circle back at the end. But that was, does the business model of the entity that the providers are employed by impact the exemption criteria? For example, cash versus HMO, PPO, or insurance lists?
Yeah, it's another good question. What I would say is the business model has nothing to do with what the regulatory impact is. So the regulatory impact simply says licensure and provider when it deals with what kind of prescriptions it's putting out there. Doesn't care whether, except in the case of whether you're doing it commercially or not, doesn't care what the business model is of the provider, whether they're working for a corporation, whether they're working as an individual, whether it's an insurance reimbursed or not, does not care from a regulatory point of view. And that's in every state that I've looked at. There is nothing there that would change based upon how that model is paid for.
Yeah, that's what I thought. Okay, great. So let's jump into international licensure and regulation. I know recently everything seems to have changed over the past 6 months, and we're starting to see some things shift in the international climate from like a data privacy data residency standpoint. So let's dive into that a little bit. Maybe you can give us a lay of the land, so to speak, and then we have an example here that we can talk about.
Yeah, and this is a great example because actually there was some new developments today in UAE that probably will have some impact on this. But let me talk about generally what we've got when we talk about international. So in the international environment, you obviously have the laws of each individual country, or in some cases, it's each individual province. So in Canada, for example, province by province, they change what the requirements are for data residency and things related to that. But when you're giving a remote or virtual second opinion in another country, you have a few other things that you should deal with. So one, you do have this licensure issue, and there are some countries that have very strict regulations on licensure, very strict. In some cases, you could immediately go to jail for practicing medicine without a license. So you want to be careful there. But to tell you the truth, that's the least of your worries in most of these countries. I don't mean that going to jail is something that you should just thumb your nose at, but the idea is that country is likely not going to come back to the United States and try to extradite you so that you can get prosecuted in that country. So whereas in state by state in the U.S., that's probably not the case, or at least it used to not be the case. We'll see if it still is. But what you have in these countries is you have a whole nother set of regulations that you have to deal with. So licensure is one, but you also have to deal with privacy, and you also have to deal with data residency. So you have to think about all of those. And a lot of countries, the EU being a region that has this requirement, Australia being a country and a region that has this requirement, and that PHI, private health information, typically in those countries must remain within the borders of that country. And transmitting that data outside of the country, storing it in a cloud-based system that's outside of that country, could be prohibited. And in many countries, it is prohibited. The UAE being an example of that, Australia being an example of that. So if you're going to give a remote or virtual second opinion to a patient, let's just say in Australia, that patient's information has to reside in Australia and has to stay in Australia. You could look at it and you can review it and you can form your opinion based upon it, but you've got to be looking at it in Australia, not looking at it in, let's just say, the United States. And you definitely don't want to be storing it in the United States. Now, many of these countries, you can get past that by having the patient sign a waiver that allows that to happen. But there still are some countries that won't allow that waiver to even be used because they say that you're taking advantage of a individual that doesn't really understand the implications of what they're doing. So you need to be careful of that. That's the data residency laws. There are privacy laws like GDPR in the EU that do govern the use of and what you have to do if you have personal information in the case of GDPR or PHI. And you need to understand what that means as well. And then, of course, I'll call it the fourth piece of complexion or overlay is you've got different languages. And so that comes up a lot. And we'll talk about the UAE in just a second, but the different languages pose a problem in two ways. One is a lot of our clients come to us and say, well, do you do translation in your software? And the short answer is we can, but you probably don't want to. And what I mean by that is if you've got a medical record that's written in a language other than the language of the natural language of your doctor, let's just say English, for example, in the United States, you run the risk that the translation could be done incorrectly, at least from a medical point of view, and that an error could be made simply because the documents were translated incorrectly. And so you don't want to own the burden of translating correctly, at least in my suggestion, my world. You'd rather have that be the patient's responsibility to get those records translated before they come to you. So the vast majority of the clients that we work with require records to come in English and be translated into English so that they can then be part of the record that the physician gives a second opinion on. So you've got language, you've got privacy, you've got data residency, and of course, you've got licensure to deal with. All of those are really important. There are lots of relationships between the US and these other countries that sometimes will bridge that gap. And so in the UAE, I was just mentioning today that I don't know if you've seen the press, but apparently we're forming a technology relationship with UAE as of today. I think it's going to be signed today. Um, and that'll help towards at least the protection of intellectual property. But you'll see other things like that bud from that relationship, including probably the ability to share data. GDPR does have that. So the EU, you actually can share data. You can take PHI and you can have it stored in the US under a data processing agreement, yet another agreement that you'd have to create between the two. But you just need to be aware of what each of those countries require in terms of the sharing of that information.
Right. And for those who are unfamiliar with what data residency means, do you mind explaining how we have circumstances where a country might require that the data is housed in that country, but that doesn't mean that there aren't ways that you, I guess, are prevented from helping patients in that country?
Yeah, so it's like what I said with Australia. Physically, the data can stay located in Australia. But that doesn't mean that we can't look at our screens and have our screens through a cloud relationship be viewing that data in Australia. It doesn't say you can't see it, it just says you can't take it out. You can't physically take it out. Now, physically taking digital data beyond state borders is kind of archaic altogether, right? What does that mean? Used to mean something that you couldn't physically carry a bottle of wine from one country to another. But it's digital data. It goes via the internet. It's really hard to regulate. But in fact, you want to be sure that you are sensitive to those regulations. But again, it's just the housing of that. It's where it physically is being served up from. So servers in Australia, data storage in Australia, viewing in the United States, not a problem, as long as you follow the privacy laws that go along with that and the licensure laws that go along with that.
Yeah. And would you agree that things in general have just become more sensitive around data privacy? I know you and I were talking to an organization in Poland not that long ago. They're within the EU who has its own data privacy standards, but they still wanted their data in Poland, if you remember.
Well, so all of this really came to a head with the Snowden situation that we had here in this country. And if you don't remember that, it had nothing to do with PHI. It had all to do with national security documents. But what that turned up was that there were ways to deal with data that were untoward in the United States. And therefore, people who were allowing their data to come into the United States were all of a sudden starting to get a little queasy, and they didn't like their data to be treated that way. There were, phone records of the Queen of England or something that were in those records when they ultimately got turned up. So that's when things started to change. And now countries, I don't know if it's for good or for bad, but countries have a real desire to make sure that the information that's kept within their borders doesn't get into somebody else's hands where it might actually be used against them.
Right. That makes sense. And we'll go a little bit deeper into international regulation in our next webinar, actually, that we are going to partner with USKIP in presenting. But we have multiple questions building up. So let's get to some of these last since we are coming up on time. So one of them is the idea of episodic deals with the idea of how much the physician is practicing in the state. I had assumed it was episodic with reference to the patient, meaning that there wasn't a treatment relationship established. So maybe you can just explain that episodic definition for us.
Yeah, I think it actually has a little to do with both. But typically when we deal with episodic, all we're meaning is that there's not a continuum of care with that patient.
Mm-hmm.
Meaning that you're not forming a physician-patient relationship where the patient's going to call you up every Thursday and say, what drug should I take now or anything like that. You also obviously prescription or writing prescriptions for drugs is completely off the table when we talk about remote anything. Telemedicine, there's some nuances there as well, but for remote second opinions or virtual second opinions, there's no prescription permitted. So episodic is that continuum of care with the patient. At least that's how we interpret episodic. We also do believe that that episodic does get defined by the how many times as well. So if you have a particular physician and a patient, If there's a continuing relationship there where they're dealing with more than one thing that's gone wrong over a long period of time, that is not episodic. And if there's a physician who does provide plain old remote second opinions to more than just a few patients in a relatively short period of time, that also is not episodic. So I think you can use both of those, again, from a logical point of view, to say, just be careful of that. Definitely no long-term patient relationship, and not unless the patient matriculates into your facility and gets a procedure done there. And then there's a whole nother set of laws that go into effect there on existing relationships between patients and physicians. But major concern is, don't let your physicians give more than just a few opinions within a particular state within a short period of time.
Right. And I think we've used the word episodic because that's what we've seen the most. But we also see, as someone else commented, the words like infrequent, which also describe that.
Occasional, there's a bunch of words. Yep.
Okay. So another one is it permissible for a healthcare provider who holds an active license, for example, in Louisiana, to deliver telehealth services to patients located in Louisiana, even if the provider is physically outside the United States at the time of the consultation? Interesting.
So that's a great question. It is a telehealth question. So it's going to be beyond the purview, if you will, of this particular webinar. But there are state regulations, and I don't know the laws specifically in Louisiana with regard to this, but there are state regulations that definitely say it's different when a provider is within the state providing telehealth or outside the state providing telehealth, even if they're licensed in the state. There are some laws that I've seen that make that a different scenario. So you just got to read the law or have somebody read the law. But it's a good question. It's kind of artificial, don't you think? It doesn't really make sense. Same person, same knowledge, same license, but now they're doing it outside the state. Tough one to believe that it's different, but there are some states that treat it differently.
Right. And I would say that none of it seems to make sense to me as far as not being able to just practice across state lines anyway. But
I like to say it's not necessarily fair or equitable, but in some cases, the states can justify it by saying it does make sense because we're trying to keep our patients safe by regulating the practice of medicine. So.
Yeah, really interesting question. And I would follow up with that by saying, if anyone listening has a specific question on a specific state and want to talk about the research, as Les said, he has each statute, and just come to us and we can drill deeper into anything that you're interested in. So another one is, if a patient translates their own records using Google, what are the implications to the hospital or physician if incorrect?
It sure is a good question, but I can tell you that if there's going to be a mistake made, I'd rather be made by the patient than made by my hospital. That's just where I sit on that issue altogether. I think that translations using Google are getting better and better, but they certainly could have errors, but so could humans in terms of translating records. They could have errors as well. So the way that these typically work is that a physician is taking into account the records that they receive. So they make no warranty for the correctness of the records they receive. The only thing they say is, from the records that I've received, I then will use my professional opinion to create a recommendation from that, and that's what I'm using. So I would say, letter of the law, it's the patient's problem at that point, not the facility's problem. Now, is that going to hold every time? I think it is. I think ultimately, when it comes down to it, doesn't mean it's great, but I think it ultimately comes down to it. The records that you receive, especially if you have an agreement, which all of our clients do have an agreement, and the person who raised this is actually one of our clients, so, or maybe one of our prospective clients. So we want to make sure that your agreement says that you make no warranty for the receipt of those records, only that you will do a good job with what you do receive.
Right. And would you differentiate that from, I guess, what I'd call the patient experience itself, where you do see translators brought in during any communication, or maybe the experience of the platform being translated itself?
I think it's a little bit different. I think if you have a live translation going on, well, let's just say the patient's in your facility and you provide an interpreter, if you will, for that patient. If there's a mistake made there in interpretation, it's probably your problem more than the patient's problem at that point. So I think that's part of that's part of the, I guess, the price of doing business with patients that don't necessarily speak the language of your physicians. These are relatively remote things that we're talking about here, but you do need to be careful about translated records.
Great. Okay, so the rest of the comments I think that we will cover here at the end. But I just have one more that maybe you could, we have a couple more coming in, so we'll take a look at those. But one other thing, if you don't mind touching on, you've mentioned documentation a couple times. I know we have a couple built-in ways that we monitor the jurisdictions as they come in and handle that documentation piece. Do you mind speaking to that for a minute so others understand just how you can build in documentation into the process?
Yeah. So as I mentioned all the way throughout the presentation, I think it's really important that you do, especially when there's a requested physician kind of language in the state where the local physician has to request you to help them out. You want to have that documented somewhere no matter what, because it's not good enough for you to just say, well, yeah, they called me and asked me to come in. So you want it documented in some fashion, but not only do you want it documented, but you want to keep it in the record. So in the case of a second opinion, in the case of our system for a second opinion, we build a whole record of documents, and that should be listed as one of the documents that you require in each of your second opinions. That'll stay with all of the records that the patient gives you. That'll stay with all of the physician's recommendations for the second opinion. All of that will stay together. So if there ever is a question that comes up, you can always refer back to that file, if you will, and it'll be in there. That way you don't have to think about where did I put that record. Even if you don't have our system, document it somewhere and make sure it's in the patient record. You probably can put it in an Epic file if you had to, or something like that. Not that we recommend Epic for somebody who's not your patient, but that's a whole nother question that we can deal with a webinar on. But you want to put it somewhere. So put it in your EHR system, put it in your billing system, put it somewhere where you have it, where you can easily get it back if you need it. And again, I think these are very remote circumstances where one of these will be needed, but it's not our job to create risks. It's our job to make sure that this gets done right.
Yeah. And I was actually thinking of the flag, the alert we put on the system when we get a case in. We will have a way to show if it is a state or jurisdiction or country that's accepted, not accepted. And so even if you were proceeding, you're at least tracking that. And
that's a whole nother question, which is how do you ensure that the patient comes from a state that you feel comfortable with? And that's something, again, that you can track that on your own. We track that in the software. So if a patient comes in from a state that's already been ordained by the organization to not be a state that you want to give a second opinion in, or territory, that'll automatically pop up. When the patient comes in, let's assume the patient's doing self-service and saying, hey, I need a second opinion from you. When it comes in, it'll have a big red flag that says, be careful. This is a patient from a state that's not one of the states that we have opined on in terms of our ability to give second opinions legally. So that's what Samantha's referring to.
We're coming up on the last 2 minutes, but there was a really interesting one raised. I'm going to try and squeeze it in here real fast before we end. And that is, are there marketing related restrictions on second opinions, assuming you've checked all the other boxes? And I think that gets into what you alluded to with the Epic situation, that there is a reason that folks segregate the second opinion request outside of the Epic system. And that almost, in my opinion, coming from a marketing background, that crosses into marketing territory, because it is usually the front end of the website and the marketing team that handles that initial inquiry or that patient data. So maybe just touch on that issue for a second, Les, and we can go deeper into that another time if we need to.
Yeah. So it is a whole topic that's worthy of its own webinar. But when you engage, or when a patient engages with you from outside of your jurisdiction, where you don't have a physician necessarily licensed, We consider those to be a lowercase p patient, not an uppercase p patient. So not a formal patient. Organizations that take that patient information, decide they're going to do a second opinion on it, but put it into Epic or any EHR system, actually are treating it exactly like you treat a capital P patient. And we worry about that because are they saying that this person is actually a patient? And legally they can't until that patient matriculates at the location, if they're, again, not licensed to practice in the state for that patient. So we try to be really careful with that. And from a marketing point of view, you just want to make sure that when you're offering your service, that you're offering your service from the state in which you are licensed, and the patient can then request whether they can get a second opinion from you or not. You may list on your website what states are good and what states aren't, or you may simply let them inquire and then you can say yes or no based upon what your determination is. But you're not going into the state and saying, hey, buddy, you want a second opinion in Arkansas? Because we can give those. You don't want to be doing that unless you are licensed in that state.
Great. Okay, so several questions came in. How do we stay up to date on this information? How do we get more information? For that, stay tuned to the follow-up. We'll send out an email with the recording, a link to the interactive map and the white paper. And we do update this, I would say, once every 6 months or so. We try and revisit this topic. We'll host another webinar like we did today, and we'll give you any updates to the topic. Les also recently presented at the American Telemedicine Association, so you never know where you're going to see us these days. And then
we'll try to let you know.
That's right. Next, we will be focusing on a similar topic as we delved into a little bit today, and go a little bit deeper into the considerations when providing international consultations and second opinions. And we'll do that in partnership with our friends at USCIP, the U.S. Cooperative for International Patient Programs. So stay tuned for that information. Sorry for going 2 minutes past, but thanks for hanging on with us. And have a great rest of your day and a great rest of your week. Thanks for joining. And thank you, Les.
Thank you. Thank you.